Peace, peace, family. This video right here is about how I was lied on and unlawfully incarcerated. Now, with that being said, before I start, I'm going to get a disclaimer. You know, apparently you can't start a GoFundMe account to ask for help for legal matters. So I'm letting y'all know, the GoFundMe account is in the link, the video description. The GoFundMe account link is in the video description of this video. So with that being said, it's at the bottom of this video. So if you want to support me, the GoFundMe account is for supporting me in regards to my personal endeavors and things in life that I may need to take care of. If you feel that there's personal things in my life that are important and you want to support me for, then you can donate at the link below. And you can show me love, and I'm asking for my community to support me in regards to personal matters in my life that I feel I need to take care of. So that being said, that's the disclaimer before GoFundMe try to say I'm violating their GoFundMe rules and regulations. Now, that being said, boom. After hearing this info, I ask that everybody listen to this video in its entirety so that y'all can hear step by step. I'm going to comb through everything that happened, all right, in regards to me legally, so that y'all can hear the blatant disregard of just New York State law by New York State magistrates and district attorneys and attorneys alike. So that being said, I'm going to break down what led me what led up to me doing the 3.5 years in prison, how I was wrongfully convicted and lied upon. And I'm in this video right here. You can send, if you know any attorneys, any lawsuit attorneys out there, civil suit attorneys out there who hear this information, you want to take this case, you can contact me at the email below in the description. Also, the email, if you don't feel like running to the description, I'm gonna give it to you now. It's ypattorney@gmail.com. So the letter Y, the letter P, the word attorney @gmail.com. Any lawyers out there see this and y'all want to contact me, I am fully welcoming y'all. I'm seeking help from legal counsel because I would like to file a civil suit as well as get this overturned and get this felony expunged off my record due to me being wrongfully convicted. And that is the point of this video. So with that being said, if you want to support me and you're watching this video, the link is in the description. Now, those are the disclaimers. Now, let me get into the case. All right. So, in 2012, I was minding my goddamn business. And I was wrongfully arrested by 2 officers. Mind you, these officers have already been under investigation before for being corrupt. So, it's not a secret that these are corrupt officers. Now, long story short, I was charged with criminal possession of a firearm in the 2nd degree. And 2 other misdemeanor charges: obstruction of justice and resisting arrest. Now, with that being said, obstruction of justice and resisting arrest didn't stay. Only the criminal possession of a weapon in the 2nd degree stuck. Now, for those of you who don't know, criminal possession of a weapon criminal possession of a fully loaded firearm or criminal possession of a weapon in the 2nd degree entails that you have a fully loaded firearm and that you intend to do bodily harm. So keep those in mind, that you intend to do bodily harm and that you have a fully loaded firearm. Now, 2 things wrong with that. For one, I was arrested on a front lawn 2 houses over from where they found the firearm. The firearm was found in a yard about 2.5 to 3 houses over with a whole dog in the yard away from where I was arrested at, which was on a goddamn front sidewalk. On somebody's front lawn by the sidewalk. So I don't live in the area I got arrested in. I don't know the damn people they found the yard. I don't even know who house that was I got arrested in front of. Now, why is this important? I didn't have possession of a firearm. It wasn't on me. I didn't have constructive possession because I don't know who the fuck house that was, and I did not know that it was a firearm back there, allegedly. So with that being said, mind you, the weapon was disassembled. Okay? So here's the catcher. How do you charge me with criminal possession of a fully loaded firearm with intent to do bodily harm if A, there was nobody around, according to the police, there was nobody around that I was aiming a gun at, I wasn't doing nothing to nobody, okay, because I'm going to go into their testimony. And then for 2, the goddamn magazine was not in the gun and it was no bullets in the magazine. So you didn't even find a fully loaded firearm. You found pieces of a weapon. You found the base of the gun, you found the magazine, and you found some live rounds, to which 2 of the rounds is missing, and nobody can account for the shells. So with that being said, you didn't even find a fully loaded firearm. How did you charge me with a fully loaded firearm? Okay, so now I'm arrested, right? I bail out, and I go to probation. Probation arrests me with an unsigned warrant from my judge. So I go to probation. My probation officer don't say nothing. I'm talking to her normal. She like, I'm gonna be right back. She leave out of the room. She come back. Put your hands behind your back. Is what she tells me. I said, why? She said, put your hands behind your back. You under arrest. I said, for what? So I refused to put my hands behind my back. Now, there's cameras in this building. If any attorneys want to confirm this, there's cameras in our probation building. So she arrests me on an unsigned warrant. Now, when I finally ask for the warrant and I get the warrant, my judge's signature is not on the warrant. So I'm sitting in jail on an unsigned warrant. I'm telling my attorney that I'm in jail on an unsigned warrant. I keep going to court in front of my probation. I keep not going to court. I keep getting visits from my attorney. I'm telling him when we go to court to bring up the fact that I'm in jail on an unsigned warrant. Ask the judge that he signed this warrant. Now, when we go to court, not only did my attorney not ask the judge, did he not sign the warrant, my judge didn't even know who I was and what I was in court for. When I went to court, my judge said, "What are you here for? Who are you?" So I find it hard to believe that my judge signed a warrant for my arrest on a goddamn piece of documentation and didn't know who the hell I was when they brought me to court. So now I go back to jail. Now, boom, I'm in jail now on an unsigned warrant. So I'm illegally arrested for probation. I've been illegally violated by probation, and I'm in jail for a firearm that I'm being illegally charged with. So now I'm in jail on 2 different illegal accounts. So now I'm sitting in jail, no bail, no nothing. They just hold me in jail. Now I keep going back to probation court because they're waiting to see if I get indicted for this new charge. So every time I go to court, I keep telling my lawyer, ask the judge, did he sign my warrant? Because I'm not about to be sitting here on no unsigned goddamn warrant. So he doesn't ask the judge. He must have went behind the scenes and talked to them or something behind the scenes, because now I get to court and they slide me on the table a warrant that's signed, but that's not the original warrant. And I have in my possession right now the original warrant. So if anybody want to see the unsigned warrant, if any attorneys out there want to see it, I have it. And let me say this now. Anything that I bring up or say out of my mouth can be confirmed 100% on transcripts or documentation. I have 100% of all documentation and transcripts that pertain to my case. I got all the motions. I got all the memorandums and orders. I got all the transcripts from all the hearings and trials and testimonies from all the officers and parties involved. So if you need to confirm anything, I have it. I'm not making this shit up. This is 100% factual. Now, with that being said, continuing on. So now I get indicted, right? But before I got indicted, I informed my attorney, which he will confirm. My original attorney. I didn't go to trial with him, but this is my first attorney. By the time I went to trial, I was on my 3rd attorney. So I informed this current attorney that I wish to be present for the grand jury. He tells me, okay. Not only did they indict me, they indicted me without allowing me my right to face my accuser and be present for my grand jury. So they violated my constitutional rights, my due process, and they violated my right to face my accuser. Now, the district attorney at the grand jury indicted me on a crime that I didn't commit because I was already in jail. I was arrested August 3rd for the alleged charge. The district attorney, out his mouth, swore under oath. He said that the crime, he got me indicted for a crime that happened on August 24th. Now, mind you, I couldn't commit the crime because I was already in jail. I have tickets to prove that I was in a box for fighting around or before August 4th. So how was I out committing a crime on August 24th when I was already in jail? So the district attorney went to the grand jury and got an indictment for me on a crime that I never committed because I was already in jail. And not only that, he committed prosecutorial misconduct and prosecutor maliciousness because he never divulged any exculpatory evidence to the grand jurors. Now, for those of you who don't know what exculpatory evidence is, exculpatory evidence, long story short, is any evidence that could deem you innocent of the crime that you allegedly being accused of committing. And the prosecutor has a ethnic code that he must uphold to present exculpatory evidence when pursuing a case. So he never told the jury that not only is he pursuing me for fully loaded weapon of a firearm, he never told them that, for one, it was fully disassembled, so it wasn't fully loaded. For 2, they didn't find it on me. For 3, I was arrested with no 911 call, no warrant, nothing, minding my own damn business. And then for 4, he never told them that I didn't have any DNA or fingerprints on the gun whatsoever. He never presented these 4 facts to the grand jury. He went in there and he told them people what he wanted to tell them, and he shape-shifted the story to fit his means in order to manifest and come back with a true bill, which is an indictment. So now I'm indicted for a firearm that I couldn't have had because I was already in goddamn jail. And then for 2, He indicted me for firearms that I didn't have no DNA on, no fingerprints on. You found it in the yard, and it wasn't even fully loaded. Okay, and I was arrested without a warrant and no 911 call. So now, boom. Mind you, the district attorney never, ever, ever said this was a typo or anything until we got to trial and I brought it up. I went to trial 2 years after I was arrested from August 3rd. Listen, I got arrested in 2012. I didn't go to trial until 2013 going on 14. And I wasn't sentenced to 2014 because I put in a 330-30 motion and got my trial overturned, which I'll break down at the end of the story. But the reason I'm bringing that up is because the district attorney at trial tried to say it was a typo. It's not a typo because you said it out your mouth. And then for two, it's not a typo because you had 2 years to correct the mistake. He didn't bring it up until I brought it up repeatedly. When my lawyer said when I went to trial with my third lawyer, he said, Your Honor, my client has been pleading with y'all that he's been in here all of this time and y'all prosecuting him for a crime he never committed. And then the district attorney tried to say it was a typo. But had I never brought that up, he would have prosecuted me and sent me upstate on a charge that I never committed, which they still end up doing. So with that being said, I'm indicted now. Now, I go to court. I have a suppression hearing. Long story short. Now, at my suppression hearing, the officers admit that they never said nothing to me. I wasn't committing a crime, nothing. And they admit that when they found the weapon, there was no distinguishable marks on it. My lawyer asked them, because I'm on my second lawyer at this time in my suppression hearing, and I got the transcripts to prove it. My lawyer asked them, are there any markings or anything on this gun that would make it distinguishable from any other weapon? The officer said no, okay? There was a lieutenant present who was a lieutenant for 27 years who also confirmed no. So, these are a lieutenant who's been a lieutenant for 27 years, got on that stand and told the truth. Now, with that being said, boom. So now, they hold me in jail for 114 days. They don't give me no verdict. I'm writing my judge, and we can, like I said, if there's any attorneys watching this, we can go to the judge's chambers and check. We can go to my county clerk's office and check the records. I'm writing my judge, asking him when is he going to give me a court date because they're holding me in court illegally without no court date. So they hold me for 114 days with no court date, no nothing. I don't know nothing about what's going on, anything. So I'm writing my judge repeated letters, asking him for a court date. I'm not getting a court date. I finally get a court date. I fire my second attorney because apparently he's not representing me correctly at all. Now, the reason I broke down the fact that the officer stated that there's no distinguishing marks on the gun because it's going to tie into when I get to trial how they allegedly identified me with the gun. Now, I'm repeatedly requesting the district attorney to fingerprint and do a DNA test on the gun. He's denying me. I have an actual letter and piece of documentation from the district attorney himself in his office stating that they are denying me my right to get a fingerprint, to get the gun fingerprinted and DNA tested to prove my innocence. So he denied me my right to prove my innocence. So that's prosecutor maliciousness because you're pursuing me for a case that you won't even give me a chance to prove that I didn't do. So how you going to charge me with criminal possession of a gun? I'm telling you it's not mine to do a DNA test and you deny me the DNA test. What kind of district attorney is you? So with that being said, what kind of interest of justice do you have? So with that being said, now I'm sitting in jail for a gun that I'm being charged with having that I didn't have. They saying it was fully loaded and I had intent to do bodily harm. Mind you, it was disassembled. They denied me DNA and fingerprinting. And then they said I had the gun on August 24th. Mind you, I was in jail since August 3rd. Okay? So with that being said, I couldn't have committed the crime because I was already in jail. And then they denied me the means to prove that I didn't commit the crime. So now, I get my new attorney, we go to trial. Now here's the kicker. When we get to trial, the gun they don't even bring the gun in the trial in a properly taped evidence bag. The forensics examiner, the lieutenant, everybody testified that the bag was altered and that there was markings and tape on the bag that they didn't put. And somebody even testified that they don't even know they didn't even see that bag before. So they must have, I don't know where they got that bag from to put that in, to bring the gun in. So they brought the gun in the trial in a raggedy exhibit bag, all in shambles, bullets here, clip here, magazine here. The officer who found the gun testified that it was the lieutenant who was a lieutenant for 27 years testified that the gun was disassembled when he got it. He testified that on the record. He testified that the gun was not assembled. the officer, the lieutenant, who was a lieutenant for 27 years, testified that some unknown officer who works at the police station that they can't identify signed the gun out of the evidence locker and took it whoever knows where. And he also testified that when he first got it, he didn't even immediately submit it to the forensics, to the CSI lab. Now, this is going to be important, family. Now, the firearms examiner, he admitted that there was no chain of custody ever established because he admitted that there's somebody in his crimes forensics lab who is supposed to handle the weapon and turn it into him for him to do the testing. He testified that person not only didn't handle the weapon, that a minimum of 2 people handled the weapon when it should have only been 1. So he testified that that a minimum of 2. So that's 2 more than the normal amount of people who's supposed to handle the weapon before him handled it. And he also testified in trial that there was writing on the bag of a signature of an unknown person that they don't know who signed out the gun. So now we in trial. I'm being charged for a firearm that not only I'm telling y'all I don't have no DNA on it. I was in jail at the time. Y'all saying I committed the crime. I couldn't have committed it. But now y'all don't even know if this the same gun because everybody's already testifying that it was signed out. So y'all don't know what the hell, don't nobody know where the hell this magical gun has come from now that I'm being charged with and I'm getting ready to spend 3.5 years of my life in prison over. So now with that being said, boom. The chain of custody is never established. The gun is never properly identified. My lawyer brings up how they said I didn't, the district attorney has prosecuted me for a crime I couldn't have committed because I was already in jail. Now, mind you, I'm in a non-jury trial. I'm trusting the judicial system to be righteous. And guess what they do? My judge allowed all of that. Non-jury, by the book. He blatantly ignored all of that illegality and allowed all of that to be admissible. So he said it was admissible for me to be charged with a crime I couldn't have committed. He didn't drop or lower my charge or reduce my charge to at least inoperable possession possession of an inoperable weapon. He still kept my firearm at an operable possession of a fully loaded weapon, even though we clearly see and that everybody clearly testified that it wasn't loaded. He allowed the chain of custody to be allegedly established when clearly everybody testified that somebody then took the gun and nobody know who it was, which clearly shows a break in the chain of custody, okay? And then there was another witness who was supposed to come testify from the crime lab that they handled the gun and they didn't even come in because they know they didn't handle the gun. So the chain of custody at this point in time was never established. I don't have no DNA or fingerprints on this gun. I'm being denied my right to even be fingerprinted or DNA tested. I'm being charged with a crime I didn't commit because I was already in jail, okay? I'm being railroaded the hell out of. Now, why did I make the point that the officers testified that there was no distinguishing marks on the weapon? Because they had no way to pinpoint the gun to me. So this is what they did, family. One of the officers allegedly testified that he seen me throw a weapon and that it made a loud thud, right? And he assumed it hit the side of the house. Now, here's the question. If you see me throw a gun, right, and my lawyer brought this up in court, it's all in the transcripts. If you saying you see me throw a gun, right, how did you find a disassembled weapon if you see me throw a gun? And my lawyer asked him. They said, so you seen him throw one black object, allegedly, right? He said, yeah. They said, but you're not sure it was just a black object. But the police officer was lying, so he said, yeah, it was an object, but now he's not sure. So now my lawyer asked him, did you see him make 3 throwing motions? The officer said no. They said, did you see him throw a black object? I mean, did you see him throw a gun? He said no. They said, did you see him throw a clip? He said no. They said, did you see him throw bullets? He said no. They said, so you don't know what you saying you see him throw. The officer said correct. So now, how you saying you see me throw a gun, but you found 3 separate exhibits of evidence that you brought in here that if I threw a gun, a clip, and a magazine, I would have had to make multiple throws. So now they caught on the stand lying on me. So now with that being said, this is how they pinned the gun on me. They stopped my trial in the middle of the trial, family. And guess what they do? The arresting officers, not crime lab, not CSI, nobody. Because when I was arrested, they never even called CSI. They never even called crime scene. The police themselves did whatever they did with the gun, wherever they got this gun from, magically out this yard. So no, the proper chain of command and custody wasn't even established. And protocol regulations weren't even followed from the initial arrest. I wasn't even read my damn Miranda rights. So with that being said, since they never called CSI, crime scene, investigation lab, in the middle of my trial, guess what they do? They stopped my trial, and the arresting officers did this. They stopped mind you, I'm at trial 2 years later after my arrest. and they go to the scene where I was arrested and take pictures of the house in the yard. Now, why is this important? My judge convicted me because he said I was in. This is what he said. It's called a repugnant verdict. When a judge gives a verdict that's completely made up and it's against the weight of the evidence and the testimony of the officers. Basically, it has nothing to do with the case. Now, the judge convicted me because he said there was paint chips on the gun, and they were able to identify that that was the gun that I was allegedly in possession of, and I was guilty of criminal possession of weapon in the second degree. Now, let me tell you why that's considered a repugnant verdict. The district attorney never, ever, ever said nothing about no paint chips being on no gun. The police already testified that there were no distinguishing markings or anything on the gun, and when asked if they seen this gun beside the same exact form, would they be able to identify it? They said no. They said there was nothing unique about the gun. I got this all in transcript. So the police never said there was no paint chips on no gun. They said there was no scratches on the gun. The district attorney never said that there was paint chips or anything on the gun. So now here's the point. Not only did the district attorney and the testifying officers never bring up anything about paint chips, they stopped my trial in the middle of trial and then went and took pictures of the crime scene. So what they did was they tried to set me up and say the loud thud that the officer allegedly heard was the gun hitting the house. Now here's the kicker. Even if the gun was thrown and hit the house, which is a lie, but even if it was, you went to that house 2 years after the event. You don't know if that house has been repainted. You don't know if the house is even the same color. So even if y'all saying there's paint chips on the gun, first of all, how are you saying there's paint chips on the gun when the district attorney just clearly on record said he never did forensics on the gun? He never tested it for DNA or fingerprints or nothing. So if the forensics lab has never issued a report from the crime lab of any traces of anything being on a gun, how is the judge coming up with the fact it's paint chips on a gun? If the crime scene man has said there's nothing on the gun that got to do with paint chips. Nobody said nothing about no goddamn paint chips. So the point I'm trying to make is if the gun was never even tested to see if it had paint chips on it, how do you know after 2 years because if they want to uphold their lie, how do you know after going to a crime scene after 2 years that the paint on the gun even matched the house? Because you're going there 2 years later. So even if it was paint on the gun, which it wasn't, because I didn't throw no damn gun. But with that being said, even if it was paint on the gun, from the initial arrest, saying that the officers were credible, how do you know that the paint on the gun now matched the paint that's on the house 2 years later? How do you know the house ain't been repainted? So that being said, the judge made up a verdict in order to convict me because I didn't have no DNA, no fingerprints on that gun. And not only that, paint chips being on a gun does not constitute possession. The officers already testified they don't know. It wasn't no distinguishing marks on the gun. They already testified they don't know allegedly what I threw. It was a black object. They already testified that they didn't see me throw a gun clips in a magazine. So how are you finding me guilty of a gun clip and magazine that's all separate from each other? Okay, not assembled at all. How did you find me guilty of a fully loaded firearm that was in front of your face that was not fully loaded? How did you find me guilty of a possession of a firearm when officers just testified they found it in a yard and they arrested me over here? How did you find me guilty of a firearm because it had paint chips on it when the gun was allegedly never tested by forensics? How? How did you do that? How was this done? So now what I did was, family, I go pro se. If you don't know what pro se is when you do your own motion. I go pro se. I put in a 330-30 motion. Now, the 330-30 motion in New York State is to get your trial set aside and to get your trial verdict set aside underneath certain grounds. So I get my trial verdict set aside and I put my grounds in there. And my grounds, I had a lot of grounds, but to give y'all just some of them, one of my grounds was that repugnant verdict. The verdict was completely made up. 2 was I was not in criminal possession of a firearm. 3 was I was overcharged. If anything, y'all should have charged me with possession of an inoperable weapon, not no fully loaded firearm. So y'all convicted me of a felony when at the most it should have been a misdemeanor. And then for 4, I went on my violation of my due process and my right to confront my confuser. Y'all never allowed me to go to the grand jury. And violation of my Brady material. My exculpatory evidence was never presented. I had all kind of charges on my 330-30. Now mind you, family. Now mind you, after all of this, my attorney lies to me. And I got my attorney on the phone. I got the phone call recorded. So there's no getting out of this. He breached the client lawyer contract. Okay? And I want my attorney to take a lie detector test. If y'all don't believe me, I want him to take a lie detector test. With that being said, my attorney, I called him on a Wednesday. The jail phones record everything. I called my attorney on a Wednesday. He told me he was submitting my 330-30 motion, right? When I got to court, my attorney came to the back on everything I love. I put this on my soul. He said, the judge does not want to look stupid and lose this case to you, so I'm throwing myself under the rug for you. I'm giving you ineffective assistance of counsel so that you can win on your appeal. I said, what? I said, what the hell is you talking about? He said, I didn't submit your motion. But he told me on the phone he submitted my motion. I didn't find out that he didn't submit my motion until I got out there. So now, I mean, till I got to court. So I get to court, I'm mad as hell. I'm on fire. So I get out there, and the judge says, your 330-30 motion has been denied due to lack of submission, failure to submit it. So basically what they said was, I never posed the argument, so the district attorney wins by default. So I got my lawyer on the phone lying to me, telling me he submitted my pro se motion, and he never did. I sent it to him, and he said he submitted it, and when we got to court, it wasn't until I got to court that he told me he was throwing me under the bus because the judge don't want to look stupid, and he was doing us both a favor, and he never submitted my motion. So I was set up, I was lied on by the goddamn New York State courts, and I need some help from whoever out there that is truly operating in the interest of justice so that we can get this matter resolved. Because I'm not about to keep dealing with this shit. This shit is affecting my life in tremendous ways that I don't need to go in right now. But with that being said, if there's any lawyers out there and you just heard this and you want to take an interest in this case, contact me at the letter Y, the letter P, the word attorney. Also, the email is in the description of this video. And if there's anybody out there who wants to support me and my means for taking care of this matter, the GoFundMe link is in the description of this video. Like I said, I guess you can't start a GoFundMe to ask for help in regards to legal services, so that's not what I'm doing. Let me make my disclosure. I'm just asking for support from my community, so I'm asking my community to support me. So share this video, send this video to attorneys, send this video to wherever you gotta go. And like I said, I have 100% of all transcripts and documentation that you need. So if you contact me and you're an attorney and you're serious, I can send you whatever you need to review. I have all of my transcripts and documentation. I got my unsigned warrant. I have all original copies. All original police report, original transcripts, original, I even got my original pro se 330-30 motion. I got my repugnant verdict. I got my unsigned warrant. I have everything that I need. And I got all of the testimony to where the district attorney, prosecute. I even got my original indictment that shows you the, me being charged with the crime on the day that I was arrested for. And I have the testimony of the district attorney swearing under oath that I committed this crime on August 24th when I was arrested August 3rd. And I was already in jail. So that being said, I have all of this evidence, and I'm putting it out here for the universe to do what it's going to do with this frequency that I'm emitting out here publicly. So that being said, share this video, y'all. I don't care what you do. Send it to your local news station. Blow this up. Blow this video up, and we're going to get some justice. Because this is ridiculous what they're doing to people. They're railroading people. Oh, and one more thing. I wrote my judge up to the appellate division, 4th division. That's our appellate division here. We rule by the 4th division. And I have the letter for that as well. Not only did the appellate division respond to me and confirm, I wrote them a 26-page letter complaining on everything that my judge did to me. After I got my trial set aside, the appellate division informed me that they were not able to step in and supersede my case until I was convicted. But my judge was placed under investigation, and everybody in the jail at that time who had my judge, who had a gun case, was switched to another judge. So now why is this important? It shows that the appellate division acknowledged somewhere illegalities in my case. But then when I went to appeal my case, they shot me. Appellate division shot me down without no legal explanation. So I don't want to be a conspiracy theorist and saying they're conspiring or they know they messed up and they don't want to let that get out. But I'm making this public here because somebody got to step in and correct this wrong. All right, somebody got to step in and correct this wrong. Period. If y'all want to play by the rules, let's play by the rules. So that being said, if we want to play by the Constitution, let's play by the Constitution. So that being said, family, like I said, share this video. Any attorney see this video and you're interested, you can email me at the description and the link, and we can go from there. So that being said, Support me, family. The GoFundMe is in the link. It's also at the bottom of this description, at the bottom of this video description. This video is on YouTube and also Facebook. So if you're watching on Facebook, it's in the description of the video beneath this video. So with that being said, help me out, family. I'm asking the public to help me out. Make this go viral. Share it even if you don't care. Just share it. Make it go viral, and we're gonna go from there. And with that being said, I love y'all. Peace.